For a verdict in a triple homicide that happened back in 2012 in Collinwood. You're looking at Jesse Melton. He was on the run for 5 years after the murder. He chose to have a bench trial instead of a jury trial, meaning the judge will decide his fate here. We could potentially get a sentencing. We'll see. Obviously, it doesn't give much time for a victim impact statement, so a judge might delay the sentencing. We're waiting for the judge to come into the courtroom. But let's show, while we're waiting, I want to show you a story filed by our reporter Paul Orlowski at the time for this triple murder at the Imperial Auto dealership. This was in Collinwood. 3 people were killed: a Brian Urak, Lori Solari, and a Babbitt Hockenberry. They were all found shot and killed. We will not miss a second of this. We don't have the all rise yet for the judge. As soon as we see that, we'll come back from the story, again filed by our Paul Orlowski at the time of the murders back in 2012.
It is now a triple homicide. All 3 victims had received gunshot wounds.
Police won't say if the shootings were execution style, but do say the bodies were in one place, all shot in the head. The owner of Imperial Auto Sales found them when he came to work this morning.
Any weapons found?
No weapons were found.
That rules out murder-suicide. So police are looking for a triple murderer. That's unsettling to neighbors like the Reverend Stanley Miller, who's pastor of Nottingham United Methodist Church across the street. He was with young people talking about dealing with police when...
And one of the young men looked out the window of the sanctuary and said, "Pastor, there's 7 police cars out there."
The neighborhood is making progress, so the killings drew a lot of attention, including Police Chief Michael McGrath and Councilman Mike Polensek, who also says things have been on the rise here.
The owner has been very cooperative, working with us to clean up the property. In fact, he's been working with the Economic Development Department.
The community is stabilizing, and they're doing a lot of things to keep the crime off the street. So I'm happy about what's going on here, but we still have to stay busy and do our work.
The Reverend Miller's words couldn't be more true if progress is to continue. In Collinwood, Paul Orlowski, 19 Action News.
And again, we're looking back live at the defendant here, Jesse Melton. He was tried. He was on the run for 5 years. He also has numerous other counts. In this case, for the killing of the 3-year-old, the grand jury indicted him on 2 counts of aggravated murder, 1 count of murder, as well as 17 other counts. So this could be a lengthy reading by the judge. As again, he chose to go for a bench trial as opposed to a jury trial. And we get the all rise as we see the judge coming into the courtroom. Let's take you live into the Cuyahoga County Court of Common Pleas.
You ready?
Yes, sir. Thank you.
Mary, do you have my file? Anything with the case number on? We are on the record in case number 630916. This case is captured State of Ohio versus Jesse Melton. I feel compelled, first before I announce my verdict, to indicate that I'm acutely aware that regardless of what my verdict is, half of the folks in the courtroom are going to be pleased and half of the courtroom is going to be displeased. I would encourage you all to keep your emotions in check. Far too often we have difficult, emotionally charged cases such as this one that result in outbursts and cause the deputies to have to make arrests of people who came into the courtroom with their freedom and they leave out the side door. So that's a necessity. There's going to be a division within the courtroom. There's going to be unhappy people and happy people. But regardless of which side you find yourself on, keep your emotions in check. Keep your emotions under control. It doesn't benefit anybody for the deputy sheriff to have to make arrests today, so let's try to avoid that. I'm also compelled to give a little bit of a procedural history of this case because I think it could be of value. This is a case that stems from a homicide from 2012, and then ultimately an indictment from 2018. So there were 6 years where this case went without an arrest. And then an officer sort of picked up the ball and began doing work in those years in between, and his work is commendable. And that's Special Agent Burke. So we appreciate Special Agent Burke's effort and the efforts of people like Special Agent Burke who are willing to take on difficult investigations and do what they can to help when it's typical or sort of local law enforcement has been unable to make significant headway. So that's Detective Burke, and also I should indicate, or Special Agent Burke and Special Agent Kunkel. Their work with regard to some of this investigation was significant and impactful. Ultimately, an indictment was returned in 2018. This case went to trial in 2021, and I think it's worth noting that the matter was, as I indicated, was tried to a jury, but there was a bifurcation, and the firearm that was used in the homicide, and it was only one firearm alleged to have been used because all of the evidence with respect to the bullets and the pellets, they all come back to one single firearm. That single count of having a weapon while under disability, that was tried to the bench, and my predecessor, Judge Ambrose, found that the government had failed to prove their case with respect to whether or not Mr. Melton had ever even, in fact, possessed a firearm. The jury returned not guilty verdicts on many of the counts, all of the aggravated murder counts, but they were hung on the counts that remained. And it was those counts that were tried to this honorable court in this past week. I indicate that just because I think there's some value in a procedural history. However, this court promised the attorneys a fresh look. Very early on, I indicated that I would reconsider all motions that had been filed. I did that. I allowed both sides to litigate every issue that they indicated to me they wanted to be heard on. And I wanted to make certain that everybody understood that there would be a fair trial here. Throughout that time, throughout the pendency of the proceedings, it was my belief that this would be a jury trial. And it wasn't until the 11th hour, I believe it was the Thursday or so before the trial began on a Monday, that a jury waiver was signed. But this time, unlike in the first case, where just the gun charge was tried to Judge Ambrose, the entire case was tried to me. But consistent with my obligation to the parties, I proceeded as though this was the first time the matter had been tried, unaffected by Judge Ambrose's not guilty verdict on the gun. One thing that jumped out at me as I sort of transitioned from my comments about the fact that the matter was tried once before is that there really appears not to have been any new evidence between the first trial and the second trial. And that's attributable to all sorts of potential causes, but nonetheless, there really was no new evidence between the first trial and the second trial. In fact, there were fewer witnesses offered in the second trial than in the first trial. And some of that could have been because it was a bench trial and not a jury trial, so maybe there was an effort to avoid redundancy. But a great deal of time was spent in this case attempting to connect the defendant, Mr. Melton, to a telephone. And the belief, I believe, was, as I understood it from listening to the trial, if Mr. Melton is responsible for this telephone, then that means he's the killer, in so many words. So the court listened to all the testimony, heard each witness testify, A lot of the lay witness testimony had to do with the phones. At least 3 separate witnesses came in an effort to connect Mr. Melton to the phone. The agent, Burke and Kunkel, both did a great deal of intellectual work as relates to the phone. And I think their work was effective, as I indicated, and successful. Because I have no doubt that that phone was Mr. Melton's phone. I have no doubt that Mr. Melton was selling drugs all over Cuyahoga County back in 2012. If you look at the phone records, I mean, it screams drug dealer. He's getting multiple phone calls at all hours of the night, 3 o'clock, 4 o'clock, 5 o'clock, but then there's no phone calls from like 5 a.m. until 5 p.m. because that's when he's sleeping. He had essentially a graveyard shift job selling drugs in the community. So that's why I do feel that there's value in commenting on the work done by the agents, because that was essentially their charge, to connect Mr. Melton to that phone. And they did that. And frankly, the prosecutor did a fantastic job as well with the witnesses that he presented to the court to make that point. Not just the technical evidence through the cell phone site analysis, but the lay witnesses who had the courage to come in and connect themselves to the defendant and represent that they knew him to be B or they knew him to be BJ. None of that was lost on the court. And I think that was effective prosecution. The difficulty is once it's been proven to the court that that phone is in fact Mr. Melton's phone, the question becomes, does that mean that there's proof beyond a reasonable doubt that he was the killer? Now, I'll indicate again, that's the same telephone evidence that was presented in the first trial that was ineffective in convincing Judge Ambrose that he was even the possessor of a gun. But now it's presented to me to prove that he was in fact the killer. So my question that I asked myself was, if he is the possessor of the gun, does that make him the killer? So the defense points out a few propositions. And I should indicate for the record that this is high-level lawyering on both sides. Mr. Filiatro is a blessing to the Cuyahoga County Prosecutor's Office. They're better off for having him. And he knows that I mean that when I say it. And Mr. Shaughnessy and Mr. McDonald did a phenomenal job defending their client. But there is a line that troubles the court and will always trouble the court, and that's B is here. It's a bad scene. Whatever you do, don't come. That's a reference to testimony from a gentleman by the name of Sal Sarley, who on 2 separate occasions showed the courage to come in and point at this defendant, who we now can say conclusively, at least I certainly can, so I think it was proven by the evidence that the prosecutor offered, that the defendant, Jesse Melton, is B. And so we have Lori Sarley sort of testifying from the grave through her brother Sal, saying that at roughly 2:30 in the morning, 2:30, 2:45, B is here, don't come, it's a bad scene. So that's certainly, if you believe he's B, which the court does, and if you believe he's there, which the court does, it becomes impossible to believe that Sal Sarley could have just guessed the name B, and then the B could match with the phone so perfectly. So certainly he was there, and certainly it was a bad scene. And then Lori Sarley, again, her life was lost in this tragically, but the last words attributable to her were don't come. She was attempting to protect her brother from whatever was going on at that auto body shop. So that's not lost on the court either. But this is where it gets interesting. That call is at 2:30 in the morning. The people who indicate that they hear shots fired indicate that the shots were fired around 4:45 or so. Actually, the testimony before this court was that the gentleman starts work at 5:30, but then there was some cleanup testimony indicated he may start work at 5. So somewhere around 4:45, likely, these gentlemen who were at work at the Cleveland Range business heard shots fired. Well, if the effort on behalf of the government is to establish that Mr. Melton is the owner of this phone, and therefore he's the killer, but yet all of the telephone evidence points to him arriving at 2:30-ish at the home, not the home, but the business, and the shots aren't fired until roughly 4:45, we have to believe that Mr. Melton was there for 2 hours, 2 hours plus. And there's just no evidence to support that. I mean, there are phone records that connect his phone to that area, but he also lived about 10 houses away, give or take. You know, in the end, my job is, just like a juror, to determine whether I've been given the kind of evidence that an ordinary person would be willing to rely and act upon in the most important of his or her own affairs. And Mr. McDonald stated in his closing argument, and it certainly has been the case throughout, there are multiple questions to which we have no answers. This is a remarkable case. Both of these two young ladies whose lives were snatched away from their families were found with someone's DNA in their pockets. We tried this case for a week, and the government offered no explanation as to why these two young ladies had someone else's DNA in their pockets. We have DNA under the fingernails of a victim. I've seen whole cases tried on the basis of DNA under the fingernails of a victim. One of these victims has unknown DNA under their fingernails, suggesting someone was scratched. It doesn't have to be that a person was scratched, but these are unknown questions. We don't have answers to them. We still don't. And even in the face of Special Agent Burke's work and Special Agent Kunkel's work, and even going back to Detective Sergeant Borden, these questions have never been able to be answered. Why is there unknown DNA in the pockets of two of the victims? It certainly suggests that somebody may have gone through their pockets, and this could have been a robbery. Now, when we think of reasonable doubt, we always keep in mind that it's not just any doubt, right? It has to be reasonable doubt. So the telephone evidence that puts him there at around 2:30, the shots are fired around 4:45. What happened in those 2 hours and 15 minutes? Well, we don't know. The prosecutor offers, in an effort to sort of explain the physical evidence that he's confronted with, these three people said the three people who are at Cleveland Range indicate they heard 3 shots fired, but we know 4 shots were fired altogether. So the prosecutor suggests, well, maybe the first shot was fired at 2:30, and then there's 3 more shots fired 2 hours later. One of the things that the court did is I went through every single picture that I had at the crime scene, and there were hundreds. Mr. Urevec, who also tragically lost his life, was, by all accounts, troubled. He was in throes of a drug addiction, and consistent with a lot of the people who I see in this courtroom, their struggle with drugs left them mixed up in street crime. So he had people coming to get him, people chasing him around. There's stories of somebody getting hit with a 2x4, and people in cars driving around looking for him. That doesn't mean that his case doesn't deserve all the court's attention. The reason why I say that is because the prosecutor suggests that the defendant broke in at 2:45, came in at 2:45, and shot him in the leg. When you look at the crime scene, there's no blood from this leg shot other than the splatter where it first happened at the entrance to the shop, but then nowhere else in the facility. And the gentleman's leg was soaked in blood. His jeans are soaked on both sides with blood. There's not even his own blood attributable to him on his hands. And you would think if you were bleeding for 2 hours, you would get blood places. As you ambulate from the front of the store to the front of the shop to the back, you would think over the course of 2 hours they would find his blood somewhere dripping. You would think he might have blood in his sock. And that's not to suggest that for every gunshot there's profuse bleeding. But if you look at these pictures, there is a significant dampening of his jeans, front and back, right in the area of the gunshot. But it doesn't travel south down his leg at any point. And there's no blood found anywhere. If this shot was fired 2 hours prior to his death, it's hard to imagine that he would have been in that shop for 2 hours and not bled on anything and not gotten even his own hand soaked in his own blood from holding his leg. I don't mean to say that that shot was fired contemporaneously. What I mean to say is there's just not evidence that that shot was fired 2 hours before, not that the trier of fact could use to conclude that it's evidence that this defendant was there for 2 hours. I referenced Mr. Uravec's personal circumstances, not to disparage him in any way. No one deserves what these people received on that day. But there is a person who came to the business in the evening, and he didn't just come in a menacing manner. But Mr. Sarley indicates that he came and his last words were, "I'll be back." And then these three people lost their lives. It's difficult to conclude that that person was the defendant because it appears that there's roughly a 6-inch gap in height between the person that Mr. Sarley identifies and the defendant. You know, I mentioned the DNA in the pocket, but obviously, you know, there's more DNA. The fingernail DNA, but also there's the absence of DNA attributable to the defendant when we allege he was in the shop for 2+ hours. It's not that it's not possible, but it makes one wonder, how could he have been there for 2+ hours and not deposited a single stitch of DNA? I don't have an answer to these questions. I don't have an answer to the question whose DNA was in these young women's pockets. I don't have an answer to the question whose DNA is under the fingernails. I don't have an answer to the question of why this defendant's DNA is nowhere at the crime scene whatsoever. I don't have an answer to the question of who this person was who said, "Tell Brian Uravec I'll be back." And I'll add just another one. As I went through every single phone call, every record that was given to me, as is my obligation to do, there are remarkable, incessant phone calls to people who the court was given no explanation as to who they are. There are like 7 calls over the course of 7 minutes from a Larry. I even asked Detective Burke, because I had seen it on the Mondo board, who the Larry was, and Detective Burke's answer, best he could on the spot, I concede, was, "I don't know who Larry is. I know there's a Larry's girl, or I think it's Larry's girlfriend," something like that. But the court was concerned about the Larry person. I don't have an answer as I'm deliberating as to who Larry is, but his phone was called, or he called Miss Hockenberry like 7 times over the course of a short few minutes. I don't know if that person is the contributor to the unknown DNA. Maybe not. I just don't know. There's just too many unanswered questions. In the end, it's the court's obligation to determine not just whether a phone is attributable to the defendant, but whether or not the defendant's guilt has been proven beyond a reasonable doubt as relates to these homicides and these counts in this indictment. And quite simply, not enough has changed since the last time this case was tried. There is still, and it looks like, unfortunately or fortunately, depending on your perspective, there will always be reasonable doubt here. So the court's verdict as to every count of this indictment is not guilty. It's my obligation. I ask no one to celebrate. This is not a cause for celebration. Mr. Melton will be ordered release as it relates to this case. If he has other holders from other jurisdictions, he'll be held. If not, on this case, he's ordered released. Mr. Filiatro, do you have any additional statements to make?
No, Judge, thank you.
Mr. McDowell and Mr. Shaughnessy?
No, sir, thank you.
I wish you all well.
Dan DeRose with 19 News. Not guilty across the board for Jesse Melton. You heard the judge in his lengthy explanation that there were just too many questions left unanswered by the prosecutors. Keep in mind, this is a case that is extremely old. It has been tried once, has now been tried a second time. And we're just going to monitor the situation. You heard the judge very strict after somebody clapped once When the verdict was read, the judge asked for no celebration. He pointed this out in the beginning of this proceeding, is that half of this room was going to be disappointed, the other half not so much. There is still 3 individuals who were shot, murdered, execution style in 2012. It happened at Imperial Auto in Collinwood, and that means there is still no one being held in account for the death of those 3 individuals: Brian Urach, Lori Sarley, and Babbitt Hockenberry. You heard the judge explain that he has no doubt that Jesse Melton was a drug dealer. He has no doubt that the phone that was found at the scene belonged to Jesse Melton that was making phone calls. And you see tears from family members in court because no one is being sent to prison at this point for the murders, the execution-style murders of their family members. It has to be extremely tough. This is the second time that this family has sat through a jury trial, now a bench trial, and they get no answers for their loved ones. Very interesting proceeding. The judge was thorough. And again, it comes down to the question of not guilty or guilty beyond a reasonable doubt. And you heard the judge say there are just too many questions. Why, if Jesse Melton is there at 2 in the morning, why do witnesses not hear gunshots for 2 hours? What were they doing? What can they prove? What did the prosecution prove they did in there for 2 hours before they were executed? There was no answer. The DNA in the pockets of the 2 women who were shot and killed, it was clear somebody had put their hands in their pockets, whether this was a robbery, whether it was after they were shot, someone reached in their pockets to get what they had. There was no explanation for that by the prosecution. There was apparently DNA under the fingernails of the women. No explanation there either. Jesse Melton is found not guilty across the board of all charges in this case. He is facing, I believe, other cases. He was on the run for 5 years after this crime, and so we will see what the future holds for Jesse Melton in other jurisdictions. I'm watching outside. Our photographer's moving out into the hallway, and I just want to make sure that there's not any issues here. It appears that the prosecution just gave an explanation to the family as to what just happened. You're going to kind of hold on this to see if any family members felt the need to speak after this verdict of not guilty for Jesse Melton. Obviously, a lot of emotions running high out in the hallway. And again, we're just going to kind of monitor this for the time being. And it does appear that the family of Jesse Melton has all left. This is, we're looking at the family of the murder victims, all 3 murder victims. You had Brian Urach, Lori Solari, and Babbitt Hockenberry, all shot in the head, execution style, at that Imperial Auto. We can show you some video from back in 2012. This was outside. This is the Collinwood neighborhood, and that was the owner getting into the back seat of that squad car there, the owner of Imperial Auto. He showed up that morning for work and found the 3 people dead, 2 of whom he did not know, 1 of whom was his employee. So we see family now exiting the premise, no comments being given at this time. So we will wrap this up. But again, Jesse Melton, who was on the run for 5 years, had to stand trial twice on this issue. been found not guilty, as you heard by the judge. There was just an extreme lack of answers and evidence in this case. If we have any other breaking news, we'll bring it to you here on our digital properties. Our 11 o'clock news coming up in just about 10 minutes on CW 43. Until then, I'm Dan DeRose with 19 News. Have a good afternoon.
19 News is everywhere. Download our CTV apps and follow us on social media at Cleveland 19 News.